Hello everyone, and welcome to Taylor Wessing's latest data protection webinar. Today's webinar is part of our data protection webinar program, where we bring you our expertise and views on topical data protection issues. Those of you who are regular attendees are going to be familiar with some of our previous topics, where we've tracked core requirements and practical applications of the GDPR. We've also considered data protection issues associated with things like disruptive technologies, which might include connected devices and big data, and as we've also talked more recently about managing cybersecurity risks. Recordings of previous webinars are still available if you've missed them and you want to engage with those topics from our Global Data Hub website. Today we will be looking at direct marketing, which is an activity that's caught in the crosshairs of two separate pieces of legislation. You've got the General Data Protection Regulation and the separate Privacy and Electronic Communications Directive and its national implementing laws, and which is due to be replaced by the very much delayed draft ePrivacy regulation. For those of you who are new to Taylor Wessing or new to our webinar program, welcome. As you'll see from the slide, Taylor Wessing is a leading international law firm, and we act for a range of leading clients in local and international markets, providing a full-service law firm offering from our office footprint, and that spans across Northern, Central, Eastern Europe, Middle East, Asia, along with US representative offices. Today's webinar is brought to you by Taylor Wessing's International Data Protection Practice. Our team advises on all aspects of data protection and information law from our office footprint that I just showed you. We're a global 22 partner-driven team, and we are also complemented by our international network of data privacy law specialists. At Taylor Wessing, we have a dedicated microsite, especially for all things data protection, our Global Data Hub. From this site, you'll be able to access news, wiki updates, and a bi-monthly mail shot if you register. Topical issues where we look at regular topics that are raising issues, challenges or concerns. And we also provide details of our forthcoming webinars along with recordings of our archived webinars. It's also where you can access checklists and tools such as our Global Data Protection Guide, which allows you to compare national data protection laws of more than 60 countries. You can also access our HR GDPR assessment tool, which provides a free assessment of key areas of GDPR risk for employee data processing. And you can also find out more about our separate TW Cyber Response app, which is designed to help companies more effectively prepare for and respond to data breaches. My name is Sally Annero, and I'm a senior member of the London Data Protection Practice, and today's webinar includes several members of our data protection team whose profile information we've made available on slides at the end of this presentation for your information, and you can access those profiles either later or via our website if you want to see them. So as I mentioned, today we're looking at direct marketing. To start with, my colleague Debbie Hayward will be considering the long-awaited replacement legislation to the Privacy and Electronic Communications Directive, the ePrivacy regulation, and she'll give us an update on the latest status of the draft replacement regulation. Then following Debbie, Lucy Lyons will be looking at that interplay between the new, in the form of the GDPR, and the old, in relation to the existing ePrivacy law, and in particular what this means in relation to consent in the context of marketing. My colleague Jane Reeves will then consider what this means in a practical sense in terms of the management of marketing databases, and then I'll be chipping in with a summary of what we are seeing in relation to regulatory action on marketing breaches in the UK by the ICO. And then finally, we'll turn to Jean-David Belleau, who will turn his attention to think about marketing interactions by social media, including by direct messaging and the implications. So, without further ado, I will be passing over to my colleague Debbie Hayward.
Thank you, Sally. We've been talking about the GDPR now for some time, and we're going to go on talking about it for years. But the GDPR and implementing member state laws like the UK's Data Protection Act are only part of the picture when it comes to rules on direct marketing. As Sally mentioned, we've long been promised an overhaul of the EU's ePrivacy Directive, which is implemented in the UK by PECA. The EC published its initial proposal way back in January 2017, and it was intended to come into effect by the 25th of May 2018 at the same time as the GDPR. Needless to say, that didn't happen, and we're still waiting. It now seems unlikely that the regulation will come in before the European elections in May 2019. For the purposes of this webinar, we're going to be looking at the draft regulation in the context of cookies and similar technologies, and in relation to what it says about rules on electronic direct marketing. So the initial draft of the regulation proposed streamlining rules on cookies so that consent to cookies could be given through browser settings and would not be needed for non-privacy intrusive cookies, which improve internet experience and cookies set to count visitors to a website. It also proposed banning unsolicited direct marketing electronic communications to consumers by any means, including phone calls, without user consent, subject to some limited exemptions, allowing member states to require that marketing callers display their phone number or use a special prefix, and also enhancing enforcement by bringing in penalties for non-compliance, which would be in line with those under the GDPR. So looking at changes made by the Council, amidst extensive lobbying, they produced a revised draft in July, which had some significant changes. The July proposal suggested a watering down of the original requirements around information which had to be given to users about third-party cookies, and the requirements to make users select privacy settings whenever new privacy options were available. The Presidency commented, in fact, that the original proposals were impractical and would result in consent fatigue. The July 2018 proposals also included further exceptions to the prohibition on dropping cookies under certain circumstances, for example for anti-fraud, security and statistical purposes, or where users are given a choice to use the services with or without cookies which collect their personal data. The most recent set of amendments was published in October, and they also made some changes to the July draft. Now, the Council hasn't finalised its position, so the October draft is the most recent one we have, and will be that one which, when it's finally agreed, which will form the basis for the next stage of approval. So what does the latest draft say? Well, before we discuss that, we do need to start thinking about consent now. So in fact, the concept of consent, both in the current directive as of 25th of May and under the draft regulation, is GDPR consent. This means consent must be freely given, informed, specific, and provide an unambiguous indication of the individual's wishes by a clear affirmative action. This has already been changed, so at least we know where we stand with consent and the way it's required in ePrivacy rules. And as we'll see, it does come up quite a lot. So while the definition of consent is clear-cut, its application to the use of cookies and other similar technologies is not entirely straightforward. Under the latest version of Article 8 of the regulation, the use of technologies like cookies to collect information from end-user terminal equipment, more commonly known as devices, or to use the processing and storage capabilities of those devices is prohibited unless it falls within one of the permitted uses. Now, these include where it's necessary for the sole purpose of carrying out the transmission of an electronic communication, where necessary for security, fraud prevention or detection of technical faults, or where necessary for a software update subject to additional requirements, and of course where the end user has given consent. Under the old definition of consent, which came from the Data Protection Directive, there was some confusion about whether consent to cookies and their equivalents could be implied, i.e. opt-out, or had to be explicit, or opt-in, with EU member states taking differing approaches. It's now clear, thanks to the GDPR, that consent has to provide an unambiguous indication of the data subject's wishes, so an action or silence will not be enough. That level of clarity is definitely helpful, but questions around how to capture specific consent remain. Under the latest Council draft of the ePrivacy regulation, the consent required to place cookies on end-user equipment can, but does not have to be, expressed by using browser settings. In previous drafts of the regulation, there was an Article 10 which contained a requirement for software, including browsers, to offer the option of preventing third parties storing information on end-user devices. On installation, the end user had to be informed about the privacy setting options and required to select their settings in order to complete installation. In relation to existing software, the privacy options had to be presented at the time of the first update and in any event by a long stop date. Now, this kind of granularity was pushed for by the European Data Protection Supervisor, and in fact, they argued that there should be further requirements around granularity of technical settings to enable full user control, and also a requirement that privacy settings should be set at their highest level by default. Neither of these elements is present in the current draft, which has deleted the original Article 10 in its entirety. Now, the cookie rules in the regulation would actually make more sense with Article 10 included. Under the GDPR, privacy by design and default is a requirement, and this means that privacy settings have to be set at their highest by default. One possible interpretation of this requirement without Article 10 is that on the day the regulation comes into effect, browsers will need to default to rejecting cookies unless they fall within an exemption to requiring consent. But what happens if the user does nothing to change this? Websites would be unable to override the browser settings by themselves, and it's the browsers that would need to ask for specific consent on a case-by-case basis. Firefox has a plugin which allows you to reject cookies, accept them on a particular site for a particular session, or accept them for a particular site on a permanent basis, but not all browsers achieve this level of granularity. And without it, setting cookie preferences through browsers is unlikely to satisfy either legal or commercial requirements. It's also difficult to see how browser settings could satisfy the requirement that consent be specific without significant granularity. Most current browser settings can be used to say yes or no to general types of cookies or prompt you to decide for yourself. But without dealing with websites individually, would consenting to a particular type of cookie on a generic basis satisfy the requirement that consent be specific? Our view at the moment is probably not, but it's too early to know for sure. The regulation in its latest iteration leaves a number of issues on cookies unclear. The most likely outcome is that in the absence of sufficiently sophisticated browser options becoming industry standard, websites will need to continue to manage their own cookies through banners and pop-ups rather than relying on browsers to do so. Moving on now to unsolicited and direct marketing. The current directive bans the use of automated calls, fax if you can remember what that is, or email for the purposes of direct marketing without consent, except in the specific case of email where the subscriber has already received goods or services from the business, in which case they can receive electronic marketing relating to similar products and services, as long as a right to opt out is provided at the time the details are collected and with each subsequent communication. In addition, Member States are required to ensure that free, unsolicited, non-electronic direct marketing communications either require the consent of the individual or allow individuals to opt out. The latest Council draft of the regulation applies a similar ban on using electronic communication services to send direct marketing communications to natural persons. It defines direct marketing communications as any form of advertising, whether written or oral, sent to one or more identified or identifiable end users of electronic communication services, including the placing of voice-to-voice calls, the use of automated calling, and communication systems with or without human interaction or electronic message, etc. Other requirements around electronic marketing in the latest draft are: anyone sending electronic direct marketing must also provide a calling line identification on which they can be contacted. Senders are also required to identify themselves with return addresses or numbers, identify the marketing communication as marketing, and provide a means to natural persons to object or withdraw consent. Member States have discretion to allow direct marketing voice-to-voice calls to natural persons who have not opted out of receiving such calls, overriding the more general ban on direct marketing to individuals without consent, and to require that all direct marketing calls have a dedicated code or prefix to identify them as such. In relation to B2B marketing, the situation under the directive at the moment is currently open to interpretation by Member States. Member States are required to ensure that, and I'm quoting, the legitimate interests of subscribers other than natural persons with regard to unsolicited communications are sufficiently protected. The UK has taken that to mean that opt-in consent is not required for B2B marketing, subject to certain exemptions. This applies even where personal names are included in business email addresses. Other member states have not, however, distinguished between B2B and B2C direct marketing and require opt-in consent, and in some cases have a preference for double opt-in for both. The latest draft of the regulation appears to preserve this position in as much as it uses very similar wording. It's unclear at the moment whether the Council's intention is to keep options open for member states around B2B marketing, or whether it considers that this clause actually applies only to marketing sent to contacts which do not contain personal data, for example info@company.com. The preservation of the wording in the directive potentially puts the ball in the court of governments and possibly regulators to decide whether to distinguish between B2C and B2B marketing, and could mean that despite the fact that the rules on electronic direct marketing are moving from a directive to a regulation, there will not be a harmonised outlook across the EU. It's also currently unclear whether the UK will seek to preserve its current position of distinguishing between B2C and B2B electronic direct marketing, if the regulation allows it to do so, or whether it will tighten requirements to an opt-in by requiring consent for all electronic marketing, both to individuals and to individual contacts within businesses. Given the regulation is unlikely to come into force before Brexit, assuming that takes place as planned on the 29th of March in 2019, there may be no requirement for the UK to change its current position on B2B marketing in any event, but it may choose to fall in line with the regulation or with EU market practice in order to preserve parity with the EU on data privacy. If you're now hopelessly confused, you are not alone, and it's very important to remember this is only a draft regulation and there's still some way to go before it gets to the final position. It's the uncertainty which has been most difficult for businesses. The most pressing issues which the final version of the regulation needs to clarify are the approach to B2B electronic unsolicited direct marketing communications and the extent to which browsers are really able to satisfy consent requirements for cookies. It would have been helpful, to be honest, if the rules had been consolidated or at least finalised in one batch. Policies and terms and conditions should already have been scrutinised and amended where necessary for the purposes of GDPR compliance. Marketing databases should have been cleansed. GDPR consent should already apply where it's being relied upon. But these processes may have to be gone through again depending on what the final version of the regulation says, and for UK businesses depending on when it comes into force and the interplay with Brexit. For now, though, the best you can do is make sure you comply with the current rules, and that's what we're going to be focusing on for the remainder of the webinar. So I'm going to hand over to Lucy, who's going to start by setting out the current position.
Thank you, Debbie. So we've just heard about the new rules that might be coming down the line, but it's important for now to pause and think about what current rules are in place. There are three key legal instruments to note here. The first is the ePrivacy Directive, which Debbie already touched on. This regulates the processing of personal data and the protection of privacy in the electronic communications sector. This is where the rules on sending marketing emails come from, not the GDPR. It specifically sets out the rules for sending unsolicited direct marketing messages, including emails. As it is a directive, it has to be implemented through local EU member states' law. It does not have direct effect. And so typically this has been interpreted and implemented differently from state to state. In the UK, we've implemented the ePrivacy Directive through PECA. It doesn't directly replicate the language of the ePrivacy Directive, but it tracks directly against it. And then the final legal instrument to note is the GDPR. As you'll know all too well, this regulates how personal data must be handled and the rights data subjects have with regard to their personal data. It also defines key personal data terms. It applies wherever personal data is concerned. So, if, for example, in sending a marketing communication via email, a company handles personal data, which will be the case where an individual can be identified indirectly or directly from an email address, it will be classed as personal data and the GDPR will apply. This means that all applicable obligations of the GDPR must be discharged. Lawful basis analysis, data transfer rules, data subject rights, but it does not set out the conditions which apply to the sending of unsolicited direct marketing emails. That's all in PECA. So, in the current landscape, you need to think about compliance with both PECA and the GDPR, satisfying the requirements of both and reviewing these against the facts of any email marketing campaign. As it's PECA that sets out the conditions required for sending marketing emails, let's look at PECA more closely. The default position established by the ePrivacy Directive, as applied by PECA in the UK, is that prior consent must be given to the sender of the email before the direct marketing email can be sent. That's the instigator of the message, where that's a different party to the sender. However, neither the ePrivacy Directive nor PECA define what consent means. What the ePrivacy Directive and PECA say is, to understand what is meant by consent, you need to look at the legislation which generally protects the handling of personal data. Before May 25th, 2018, that used to be the Data Protection Directive, as implemented by various member state laws, but the GDPR replaced it. So post 25th of May, we now have to look at what GDPR means by consent. As Debbie mentioned earlier, and as you can see in the slides, you can see the difference that GDPR made to the definition of consent. And it's really the last section that specifically upgrades this, requiring a clear affirmative action. GDPR instantly upgraded what the standard was we were expecting from consent, and it leaves no room for a weaker interpretation. It also reinforces the GDPR's wider obligations for consent to be demonstrated by the controller and the principle of accountability. As mentioned above, other GDPR obligations will be relevant too in the course of obtaining consent for marketing. So there'll be general GDPR obligations to discharge, such as transparency requirements, data transfer rules, and so on and so forth. And specifically, because consent will be used as the relevant lawful basis. Without going into a detailed analysis on consent requirements, this will include communicating to the data subject that they can withdraw consent at any time, being able to demonstrate consent, identifying the controller to which the consent is to be given, offering a genuine choice, and therefore not generally bundling up consent with another condition, and presenting clearly and plainly, where possible, with reference to each specific processing activity and purpose. For some European countries, as Debbie had mentioned, the GDPR standard of consent, or very close to it, was already being applied long before GDPR came into force. So country to country across the EU, the impact of the upgraded definition has been different. For example, in Germany, the court's preferred method and market practice has for some time to use double opt-in as a way to verify consent of a data subject and demonstrate it was validly collected. For example, where an unchecked box is ticked next to clear and specific consent wording, and then a verification email is sent to the email address submitted, requiring recipients to verify consent by clicking on a link. This is an example of how best to demonstrate consent. The double opt-in allows consent to be verified with an electronic trail as evidence. As a result, in the post-GDPR world, double opt-in may become more widely used, even though not strictly prescribed into the GDPR requirements. So we've spoken about the default position in the UK, which is to require consent, but are there any exceptions to this rule? In short, yes. There are a few options that we can explore. One exception is the soft opt-in. It can only be applied under certain conditions, which you can see on the slide in front of you. The soft opt-in also only applies to commercial marketing. For example, charities and political parties will fall under the default position requiring consent. Whether the soft opt-in can be used will be dependent on the facts, and specific analysis will be required. It may also be narrowly construed by regulators and courts alike. And again, across Europe, the approach is not uniform. So what is permitted to be a soft opt-in exception in one country may not work in others. Although email marketing is not all about the GDPR, it cannot be forgotten. And so, as with all mechanisms for marketing, the soft opt-in is still going to involve the handling of personal data, so the GDPR will still apply. It's just the upgrading of consent didn't affect the soft opt-in exception. So, for example, again, discharging relevant GDPR obligations, such as meeting transparency requirements and presenting an option to opt out, among others, are applicable to the soft opt-in. It's worth noting here that the ICO is currently undertaking a call for views on its direct marketing guidance, and I'll touch on that a little further in a moment. But it's possible that the updated guidance may impact the soft opt-in, and so any ICO updates and future guidance should be monitored closely. Another exception to the strict default position for the requirement for consent is around B2B marketing, again, as Debbie touched on earlier. In the UK, we currently do treat some businesses and consumer marketing differently. The rules on consent and the soft opt-in don't apply to corporate subscribers, that is, companies and other corporate bodies such as LLPs and government bodies. However, it's important to note that sole traders and some partnerships are not classed as corporate subscribers, and they will be treated as individuals, and therefore the default requirement for consent applies. The UK approach to date, for example, has been to make a distinction between individual personal email addresses and employee corporate email addresses, first name dot last name at company.com, for example. In the email marketing for the latter does not fall under the rules on consent. However, as always, the GDPR does still apply to such corporate email addresses, as these are personal data and as an individual can directly or indirectly be identified with it. This means that companies still need to undertake a lawful basis analysis, meet transparency requirements, and ensure that corporate subscribers can object to marketing, among other GDPR requirements. There are also a few wider practical issues to consider. For example, when relying on a corporate subscriber mailing list, it should not include any individuals. How to practically check and keep this under review and be able to evidence this is important. Specific analysis of processes against the legal conditions is required to check that no individual will fall into this list. Again, as mentioned earlier, as Member States have interpreted and applied the ePrivacy Directive differently, how Member States define and treat business and consumer marketing is not uniform. The specific consideration of local requirements is key. B2B marketing requirements for the UK may also be impacted by the ICO's revised marketing guidance. So again, watch this space. Picking up on that latter point again, it was just last week that the ICO opened a call for views on its direct marketing code of practice. The latest ICO direct marketing guidance has not been reviewed to consider PECA alongside the GDPR specifically. And with the timing and content of the ePrivacy regulation being less clear, as we heard earlier, the ICO is seeking to address the current gap in guidance and help navigate the legal landscape. After the ePrivacy regulation is finalised, and the UK has confirmed its position in relation to this, the guidance will then be updated to take into account the UK approach as required. It's clear for now that marketing compliance remains firmly on the agenda of the ICO, and that various updates coming down the line need to be closely monitored. I'll now hand over to my colleague Jane, who will look at managing marketing databases.
Thank you very much, Lucy. So, we're sort of assuming that perhaps by now your direct marketing practices are in reasonably good shape. You've got a great privacy statement, it's comprehensive, it's transparent, and you might even have a good GDPR compliant consent mechanism so that you can work out whether people are consenting to your marketing and be able to evidence that. The kicker is that even if you had all of this in place by the 26th of May when GDPR became effective, you've now got to consider what you're going to do with all the data that you collected before May the 25th, because the GDPR will apply equally to all of that data. And what you think at the moment is a marketing asset might actually turn out to be a liability. So, 4 questions I think you need to ask yourself. The first question is going to be, where are your marketing contacts? As Lucy has just explained, the new ePrivacy regulation hasn't come into effect yet, so we're still working under the old directive. And different countries have implemented the directive in different ways. Lucy was explaining about the double opt-in Germany. That means you need to work out where each of your marketing contacts is resident to work out which law applies to them. Because that's actually a complicated and difficult matter, I'm going to assume now that all of your marketing contacts are in the UK. The second thing you need to work out, again, is whether you're marketing B2B or B2C. Because as you just heard, B2C marketing requires direct consent, whereas B2B marketing doesn't. But watch out for individuals who are actually part of an unlimited partnership or who are sole traders, because they are considered to be consumers. And I think what you may find is, in a very large database, it's going to be difficult to pick through that database to work out who is who. The next thing you want to think about is, did you, in that rush before the 25th of May, send out one of those GDPR emails? That may well be the case, because it seemed like hundreds of thousands of them were sent out and received at that time. Whatever you said in that GDPR email may have changed your legal position. So you're going to have to review that very carefully and work out where you stand now. And that may be something where you will need legal advice. So again, looking for the rest of this presentation, we'll assume that you resisted that temptation and didn't send out a pre-25th of May GDPR email. Finally, I think if you've got a large marketing database, it might be worth thinking about whether all the contacts in it are still useful. If they're more than 2 or 3 years old, if they haven't responded to you, if nothing is coming back from them, then are these contacts actually useful? And are you using them for the purpose for which you collected the data? Or are they just sitting out there unused? There are no hard and fast rules about when you might put in a cut-off date. And a lot is going to depend on circumstances, but you definitely should think about having a date at which you start to delete your contacts. Going on. Sorry, I'm going backwards. You've now got to work out whether or not you've obtained the right level of consent. And Lucy has talked about the different ways in which you can obtain consent. So there are 3 ways to obtain consent. The first way, which Lucy's talked about, is getting a direct consent. So this is where you have a tick in the box, where somebody makes an affirmative action saying that they have consented. The second way is the soft opt-in. So you already have, this is a customer that you already have and have been dealing with, and you can imply their consent to direct marketing. And a third way is where another third party has got consent for you. So we'll just have a quick look at each of these ways of getting consent. So starting with the contacts where you're relying on direct consent. For these contacts, even if you obtain them before the GDPR became effective, your consent must be at a GDPR standard. And as you just heard, that's a very high standard to reach. In a nutshell, it must be freely given, specific, informed, and unambiguous. So if you have, for example, pre-25th of May been using pre-ticked boxes, it's unlikely that your consent will reach that GDPR standard. And you may have to think about whether or not you're going to have to delete those contacts from your database because you haven't got the consent you needed. So you've looked at your direct consent. You may also, within the same database, be relying on soft opt-in consents. So these are where you have you've had a sale or you have negotiations for sale with that contact. One of the key areas and pitfalls in this area is that you have to have informed those contacts about their right to opt out and how they're going to do it at the point at which you collected their data. So not in the email that came afterwards, but at the very point where they put their data in and press submit. And you can only market to them goods or services that are similar to the ones that have been previously purchased. So if you think your soft opt-in consents do not meet that standard, for example, you didn't give that notice about how to opt out at the time you collected their data, again, you may have to think about whether or not you're going to delete those contacts from your database. Finally, some of your contacts may have been passed on to you by third parties, maybe a list vendor, or perhaps an event organizer for an event you were connected with. There is a very high threshold in the GDPR for marketing to somebody else. The individual must have consented specifically to marketing from you by name, or to marketing from a very precise, well-defined category of entities into which you and your company come. So again, if you look at your third-party consents and realise that they don't reach that threshold, then you may have to think about whether or not you're going to delete them from your database. So, what are you going to do next? I think you've now segmented your database and you've identified all of those contacts that haven't met GDPR standards. So the next thing to do is work on a strategy for how to address them. It's fair to say that if your database is not met, if your contacts haven't met GDPR standards of consent, then the gold standard here is just to delete them. However, there may be other approaches available to you. Those approaches are likely to have some level of reputational, legal, or commercial risk attached to them. So you're going to have to think very carefully and probably work with your legal advisors on how to implement those strategies. Thank you very much, and I'm now passing on to Sally.
Thanks, Jane. So, marketing has historically been a key focus area for regulatory action by the UK's Information Commissioner, or ICO. And this can take the form of warnings and go all the way through to enforcement and monetary penalties that are issued under the relevant data protection law in relation to contraventions of the ePrivacy Directive. In the case of the UK's regulations implement the directive. I say relevant data protection law because to date the Information Commissioner's, the ICO enforcement activity has focused on breach matters that occurred prior to GDPR entering into force. Obviously that situation is going to change and we're going to start to see more of those actions being brought under the Data Protection Act 2018, which is the implementing the GDPR into UK law where required. But to date we're still seeing enforcement action that references the Data Protection Act 98. That said, there's been significant regulatory activity in this area in recent years, with the ICO issuing fines of over £4 million against unsolicited or nuisance marketing. The focus of this ICO activity has been on mass marketing, or marketing where the number of complaints to the ICO has tripped their regulatory threshold for intervention, and I'll say a bit more about that later. So a key challenge in relation to that nuisance end of the marketing spectrum has been dealing with the rogue directors whose response to penalties that the ICO has issued has been simply to liquidate the business, only to incorporate a new business and start all over again, which is a practice called phoenixing, sort of where the new sort of liability-free business rises from the ashes of the old business. After the insolvency service can seek directorship disqualifications in relation to those rogue directors, there tends to need to be significant evidence of past bad form in order for them to be prompted to take that kind of action, which means that typically there would be a long lead time for that kind of action to be taken. With this and the desire to curb marketing excesses in certain sectors, there's been a number of recent and pending developments that are likely to enable more effective regulation of certain marketing activities by the ICO. First of all, we've got new rules that entered into force on the 8th of September this year by way of amendments to PECA, or the Privacy Electronic Communications Regulations, basically UK regulations implementing the directive. And those amendments were made by way of Section 35 of the Financial Guidance and Claims Act. Secondly, we had draft amendments that were due to be set before Parliament before the end of the year to ban pensions cold calling. Again, subject to parliamentary approval, these will then be brought into force as soon as possible afterwards. And thirdly, we have the government currently considering responses to a consultation it ran over the summer on proposals to amend PECA to give the ICO the power to impose fines on directors, making them personally liable for PECA breaches. So I might just touch on each of those in a little bit more detail. So first, if we look at these new rules by way of amendments to PECA, in essence, these rules require that marketing calls by claims management companies can now only be made with the prior opt-in consent of the recipient. So these rules apply equally where calls are made in relation to selling advice or financial services, or in relation to representation of people or making introductions or inquiries. In relation to the amended regulations that are due to be approved later this year on banning pensions cold calling, these regulations propose that calls promoting occupation or personal pensions or products that might be acquired using pension funds in those schemes, or offering of advice or support or pension services, or advice in relation to the movement of funds from pension schemes, or the performance of the scheme, then those again can only be made with prior opt-in consent of the consumer recipient of the email. And there's the exceptions to this where the caller is a trustee or a manager of a pension scheme, or a financial conduct authority authorised firm, and the recipient has consented to such calls, or the recipient's an existing customer of the organisation that's making the call, and that they expected to receive calls from that organisation, and like with the soft opt-in, they were given the opportunity to refuse to provide their contact details and didn't opt out. As mentioned, to say those regulations are intended to come before Parliament before the end of this year by way of affirmative procedure. And then, as I say, I mentioned that the third option is this consultation, which we're still waiting to hear from the government on the results of, in relation to amending PECA to give the ICO the power to impose fines directly on directors. In other words, their history will follow them, and the regulator will be able to impose fines for their past deeds in relation to a business that they have folded. It's worth bearing in mind, however, that although nuisance mass marketers grab the headlines, this activity has meant that the ICO has quite a well-oiled enforcement strategy and a pretty no-nonsense approach to marketing complaints generally, and they will treat all such complaints as potentially reflecting a broader nuisance in the absence of evidence to the contrary. In considering complaints, the ICO will look at factors such as the seriousness of the breach, the types of data involved, the numbers of individuals that have been impacted, the pattern on complaints, including whether this is sort of the first time they've heard of this organisation, or whether it's repeated marketing. So the ICO therefore does monitor the complaints that it gets about marketing and the organisations behind that marketing, in order to gauge the level of action that it may need to take. So, just one badly executed campaign that generates lots of complaints could be a trigger for the ICO to intervene. Or it could be as a result of a steady flow of individual complaints over a period of time about different marketing campaigns by an organisation. However, once the ICO's antennae is engaged, then businesses can expect some pretty detailed questioning and will have to provide full information to evidence a range of matters, including the source of their data, what the lawful basis of their marketing is. So that will be relevant depending on whether it's B2B or B2C marketing. The total numbers of communications that have been sent or made over a period, for example, they may ask for figures that go back for the last year in terms of the number of marketing communications sent or made. They may also ask for information about the number of opt-outs, the number of bounce-backs, the number of complaints, and how all those complaints were handled. The questioning may also extend to matters such as the policies, the procedures, and the training that's in place within the organisation. In the face of that level of scrutiny, marketing campaigns must therefore also focus on the sort of the metadata of their compliance and their ability to be able to access and deliver up information that evidences compliance in the face of that level of intense ICO scrutiny. And moving on now, I will pass over to my colleague Jean-David to talk about social media.
Thank you very much, Sally. In the last 10 minutes or so, I will focus on the topic of social media and marketing. Social media is a powerful marketing tool, and many organizations use the data collected from social media platforms to drive their strategy. And we have seen a lot of interesting developments in that area recently and wanted to share our thoughts with you today. I'm conscious that I have little time left, so please feel free to ask questions at the end of the session, and we will do our best to answer them. If we can't answer them all, please feel free to contact one of us directly if you have any queries. But let's look at what happened recently first. So, social media has been in the spotlight lately, and mainly in relation to the Facebook Analytica applications concerning the use of data analytics in political campaigns. And if you look at the ICO enforcement in that area, just to give you a flavor, the ICO published a report earlier this month in relation to the use of data analytics in political campaigns, which included, in some instances, the use of social media. And following its investigation, the ICO issued 5 notices of intent and monetary penalties, and including the monetary penalty of £500,000 imposed on Facebook for breaches of the GDPR 1998. 3 enforcement notices, including an enforcement notice requiring the company AYQ to stop processing personal data retained UK citizen data. And the ICO was concerned in relation to the application of techniques reserved for commercial behavioral advertising applied to political campaigns during a referendum campaign in 2016. The ICO also issued 1 criminal prosecution, and we are aware that there are various regulatory actions and some audits being conducted at the moment by the ICO as well. There is another area which attracted attention, which is the ad tech and data broking industry. In fact, complaints have been filed by various individuals and privacy groups. 2 complaints have been issued on the 12th of September of this year. 1 complaint has been brought before the Irish Protection Commissioner, which is the grounds of complaint, by somebody called Johnny Ryan. He's a chief policy officer at a company called Brave Software, and he wanted to raise concerns regarding the behavioral advertising industry. And what he wanted to do, he wanted the Irish Protection Commissioner to look into the various practices in that very specific industry. A very similar complaint had been brought before the ICO on the same day, which is called a request for an assessment notice, which is basically an invitation to issue good practice guidance again in relation to behavioral advertising from Mr. James Culloch and Mr. Michael Ville. More recently, in November of this year, a non-profit organization called Privacy International raised 3 complaints against 7 companies in the ad tech industry. And again, they invited the ICO and other European regulators to look at their compliance with the GDPR. But again, you may remember that this is not new because in 2014, the FTC, the Federal Trade Commission in the US, issued a report on data brokers, and the ICO as well the same year conducted an investigation from May to August 2014 in relation to credit reference agencies as well. So watch this space to see what will come out of these complaints. So now let's look at the privacy risks, which are very specific to social media and marketing, to understand the challenges that the industry is facing. So there are several practices which characterize the use of social media for direct marketing purposes. The first one is the volume of personal data collected. Businesses which use social media as part of their marketing strategy collect a high volume of personal data, whether they are collecting the data directly from the users, i.e. acting as a first party, or receiving that data from first party, i.e. acting as a third party recipient. And there are several reasons which could explain why social media involves collecting a high volume of personal data. One of them is that the number of social media platforms made available by organizations to users and as part of the promotion of their products and services have increased exponentially. This includes YouTube, LinkedIn, Facebook, Instagram, etc., as well as the number of users using those platforms. From smartphones and tablets to over-the-top platforms and social media networks, content is increasingly being created and shared online via social media. Another reason is the nature of social media itself, which, in a nutshell, really, is an online environment where, as I said earlier, content is created, promoted, shared for purposes which are primarily related to social media, to social activities, where users will share their experiences and personal content through various mediums. And if you add to it tools which help to facilitate social media, such as blogs, forums, location-based services, as well as the use of new technologies such as AI, virtual reality, voice technologies and assistants, the Internet of Things, which are all enablers that help marketers reach consumers in innovative ways, ending up being data-rich activities. And the use of social media and that data as marketing purposes also means profiling. The data collected for social media uses can in fact be used to reveal, predict, and monitor an individual's browsing habits or online behavior. And such data can be segmented, categorized, formatted, matched, and analyzed at an individual and aggregate level as well. The data is used to provide targeted and personalized ads and marketing communications to individual social media users or in a distant group presenting similar online patterns or preferences. Another characteristic of the social media usage is data sharing, which is extremely important in the social media chain, because where personal data is collected, it is shared across multiple devices, across social media platforms, as well as between a lot of third-party recipients. And the volume of the data sharing is so important that it represents high risk from a security perspective, and the lines become so blurry that it becomes so difficult to comply with the GDPR requirements in particular, the principles of fairly lawfully processing personal data. One example is when buying in a marketing list and lifestyle data from data brokers because the source of data isn't always clear. So organizations need to implement privacy and security safeguards to provide individuals with a level of clarity, transparency, and security required by the GDPR when engaging with them on social media. So how can you do this? Well, it's really going back to the privacy basics. And one of them is transparency, which is a key requirement of the GDPR. And organizations which have a good understanding and control over the data flow and activities will have no difficulty at all in complying with the transparency principle. To fulfill that principle and the transparency requirements, as an organization, you must provide certain information to social media users. For example, you have privacy policy, including the type of personal data collected, including cookies, identifiers, where the data comes from, i.e. the sources, how it is shared, and with whom, i.e. the jurisdictions, and the purposes for such processing. The type of notice should also be provided by organizations acting as controllers to users where those organizations do not have a direct relationship with the user, but collect their personal data from other sources. And that's one of the main issues in relation to social media using in the context of marketing. Another principle which is very important is the GDPR requires that personal data being processed lawfully. This requires that an assessment of the lawful basis be made and the relevant lawful basis be expressly set out in the privacy statement in relation to each processing operation. And where social media is used for direct marketing purposes, the requirements of the GDPR and the privacy rules must also be considered. As mentioned by my colleague Lucy earlier, the UK have specific rules which vary depending on whether the communications are sent in a B2B or B2C context. And I invite you to go back to the slide and the presentation later if you want to look at the rules which are very specific to that area. Organizations are required to demonstrate that the data subject consenting to the processing operation when it's required by the privacy rules, and that the consent can be easily withdrawn at any time. And it would be also prudent for a third party receiving the data to seek confirmation that the data has been lawfully collected and ask for evidence of consent. So what else should be done? When we mentioned the privacy and security risk, and given those risks associated with data analytics and profiling, if you are using social media for marketing purposes, you should assess whether the data protection assessment is required from a GDPR perspective, and even if it is not, whether it would be desirable to conduct one to mitigate the potential impact on individuals and have better control over the data flows. Data protection by design and by default should also be considered and built into processing systems to ensure that the source of personal data flowing into the organization is tracked and can be tracked back to the source at any point in the data processing lifecycle. Another important point is managing third-party controllers, because the chain is very complex, as I said, especially in the ad tech environment, and this is probably the most difficult part of the exercise. Transparency, lawful basis, and privacy impact assessment may look actually easy, the easier bits, but managing your third-party controls is going to be very important. And one way to do this is to cooperate with other parties which receive and analyze such data to ensure that the data ecosystem is transparent and secure, and the basic data protection and accountability principles are complied with. This means sitting down and making sure that everyone understands each party's role in the data processing activity that you are all playing. We know that in some industries are more willing to do this, and we are discussing with some clients to have them do this. And one example is the transparency and consent framework, which has been developed by the Interactive Advertising Bureau with the support of several companies working in the digital advertising chain. So what next? Well, the recent ICO investigation and fines was the use of data analytics in political campaign. And the criticism of data brokers' practices show that organizations are under increasing scrutiny in relation to the quality of their data notices and the way they manage their social media activities. We are aware that the ICO has been looking at the services and operation of credit reference agencies. We are also aware that they are working on projects in that area as well. So from our perspective, really, in order to have a good understanding of the data flow and activities, an organization may find useful to set out the end-user journey of each social media channel and use the record data protected activities required under Article 30 of the GDPR. And that good understanding and maybe data mapping will really help you cooperate with your third-party controllers and comply with your GDPR obligations and ePrivacy rules as well. So this is the end of the presentation, and now we are going to turn to questions as well.
Thanks very much, Jean-David. So yes, we've now reached that point in the webinar where we try and collect and share some aggregate feedback on current approaches to compliance in this area by the audience today. So just to bring you through our polling questions. So I'll read through all of these questions now, but you'll get to see each of them in turn and to indicate your answer. So the first question is, have you implemented revised cookie technical consent solutions and notices? So yes, they have been revised based on GDPR consent requirements. B, no, not yet, but these are in progress. Or C, you're actually going to wait to see what the outcome of the finalisation of the ePrivacy regulation is before revisiting cookie compliance. 2, the second question, are you logging key metrics for all marketing campaigns, including the handling complaints they generate and reporting these to management for internal governance and accountability purposes? A, yes, and B, no. And thirdly, do you define acceptable use standards specifically for the use of social media for marketing? A, yes, and B, no. So while you're working through those questions, we'll look at some of the questions that we have had in from the audience. One of the questions we've had is, have any claims management companies been punished under the changes to PECA? Certainly, claims management companies have been amongst those that have been receiving penalties. These are still actions brought under the old Data Protection Act for breaches of the UK's implementation of the current Privacy and Electronic Communications Directive. If you go to the Information Commissioner's website, you will see a list of all the penalties that have been issued. Or alternatively, you can just search under penalty notices, ICO, and you'll see a list of the companies that have been fined in that space, not wanting to actually name particular companies, but you will certainly find some details there. Another question we've had is where we were talking about the ePrivacy regulation and the fact that it's still in draft form, and whether there was any idea about when this draft is actually going to get finalised and likely to enter into force. Lucy, do you want to speak to that one?
Yeah, so I think on current timings, we think the ePrivacy regulation won't be finalised until before the European elections, which are in May 2019. So it seems unlikely that it would come into effect before beginning of 2020, although things are obviously subject to change. So until that time, we'll have ePrivacy Directive as implemented by PECA in the UK.
Perfect, thank you. So I think we're just starting to get we've got the results back from the polling question. So just to remind you, the first question was, have you implemented revised cookie technical consent solutions and notices? Yes, based on the GDPR consent requirements, or no, not yet, but in progress, and C, plan to wait for finalisation of the ePrivacy regulation. So 65% of the respondents replied yes, that they had implemented a solution based on GDPR consent solutions. So a slight majority for having taken some action, but still there's quite a proportion of respondents there that haven't yet progressed this or are waiting to revisit the privacy regulation. And just getting the rest of the results back as well. Here we go. So in terms of question 2, whether you are logging key metrics for all marketing campaigns, including the handling of complaints they generate and reporting those to management for internal governance and accountability. Again, slight majority, 54%, said yes, they were, but quite clearly, again, that's, it's almost only just under half of the listeners who are not currently doing that. And I think that's quite interesting because it's certainly something that, given how the importance of the penalties or the intensity of the questioning that you can get from the regulator where things do go wrong, that it's something that the management should be very much aware of, so that they almost can sort of anticipate and try and prevent what might be complaints ending up as something that you're under the spotlight from the Information Commissioner's office from. So much tied up with brand and reputation now that it's quite interesting that it's something that's still not something that perhaps management have a huge amount of visibility to. And then the third question was, do you define acceptable use standards for the use of social media for marketing? Obviously, many organisations may have social media standards for things you can and cannot say, generally on social media, but whether or not that extends to how whether you can or cannot direct message, or whether you can export contacts from a social media account into your own CRM system, that may not form part of those guidances. And currently, 36% people said that yes, they do incorporate standards around use of social media for marketing in their policies, but 64% do not, which again is quite an interesting figure. So with that brings us to the end of our session today. But I just wanted to let you know that a recording of the webinar and the slides are going to shortly be available on the Global Data Hub microsite, and you'll also be able to access details of our future forthcoming events and webinars from that site as well. So with that, it's just left for me to thank you for attending today, to thank my colleagues for joining for this session, and I hope you can all join us again soon. Thanks a lot. Bye-bye.